Welcome to the Society of Labour Lawyers webinar on immigration law and COVID-19. I'm Catherine Atkinson. I'm Secretary of the Society of Labour Lawyers and a barrister at 9 Gough Square. This evening we have got four brilliant speakers for you. We have Adrian Berry, barrister at Garden Court Chambers. We have Ahmad Namazie, who is at Magrath Sheldrick Solicitors, and we have Yawar Abbas from Fox Williams Solicitors, and Holly Lynch MP for Halifax and the Shadow Minister of State for Immigration. So with four speakers this evening, I'm going to be a little bit stricter than I often am with timescales and ask speakers to try and keep within their 5 minutes, after which we will open up to members to be able to ask questions and make contributions, and they'll just put their hand up to me so I can see that they would like to. But if we can start with Adrian.
Great, thanks very much. In outline, in the 5 minutes that we have to cover a lot of issues. So I'll just bullet point the things that we need to be aware of as Labour Party members. There are some burning issues in respect of the Home Office treatment of NHS workers and workers in social care that we need to be aware of. It's not just whether or not those who are subject to immigration control have their leave to remain extended automatically. It's the class of people who have their leave, who are to have their leave extended. So not just doctors and nurses, but also hospital porters, paramedics, and other people that work in hospital care settings, and also the people that work in social care settings as well. At the moment, the Home Office commitment is only to doctors and nurses and so on, and it doesn't extend to other people that work in a hospital setting beyond that. And it doesn't also extend to agency workers and bank workers who may be working in private hospitals but providing NHS care as a result of the developments in the crisis. So there are things that we need to campaign on and think about around that. Another second burning issue is the question of persons subject to immigration control with a no recourse to public funds restriction, which means they can't access both out of work benefits and in work benefits as well. So obviously what we used to think of as housing benefit and working tax credits and the things which are now increasingly wrapped up in universal credit, those can all be in work benefits as well as out of work benefits. And at a time when people's work is precarious or reduced, or they may be facing unemployment, migrants with a no recourse to public funds restriction on their visa endorsements or on their residence permits are particularly vulnerable. There's then also a third group of people who need particularly to be on our radar, and those are people who are in detention, immigration detention, both those who are not just foreign national prisoners, but people who are detained for the purpose of removal more generally, if there are no flights, if they're unable to travel, if they're self-isolating, if the country of their nationality won't receive them, then there's no prospect of their removal within a reasonable period of time. They should be released on that basis, as there's no lawful basis for their immigration detention, or certainly accommodated in safe and secure housing where they're not at further risk, because of course in detention there are problems with the conditions of detention and whether or not there's a risk of coronavirus spreading in immigration detention. Finally, just as a fourth group of people who need to be particularly on our radar, people for whom there are reasonable grounds to suspect they might be victims of trafficking, whose applications for status determinations within that procedure are being held up, either because they can't enroll their biometrics or because it's impossible to get the necessary evidence to prove that they may be a victim of trafficking. They need to be granted leave to remain, the right to work, and access to public funds on an exceptional basis. So one way of yoking all of these groups of people together would be to create an order to give them some form of short-term leave to remain by statutory instrument, rather than having to make people apply for things on an individual basis, because that depends on whether they have access to a lawyer, access to advice, the know-how, English language skills, and so on. And it'd be far better and easier if we had a statutory instrument that recognised, and it's possible to do so under the 1971 Immigration Act, that granted leave to remain to a whole cohort of people who are prejudiced by the current situation, but for a fixed period of time, without them having to take individual steps and pay the fees for it. That's my 5 minutes.
Fantastic, a great opening covering a lot of different issues in a short space of time. Can I move on to Ahmad Namazie, solicitor at Magrath Sheldrick Ahmed.
Thank you, Catherine. Thanks, Adrian. So I suppose I'm going to cover some of the Home Office responses to the pandemic, some of the measures they've rolled out and the range of shortcomings therein. We've really seen in the Home Office response both a complete lack of cohesive strategy in the way they approach, in the way they've approached the visa system for this period of time, delays in rolling out measures which have caused a huge amount of upheaval and a total lack of clarity, both for individuals and employers. And just that a lot of these issues are ongoing issues with the Home Office that are not particular to this circumstance. It's just that the pandemic exacerbates them. So on the approach that the Home Office have engaged with, if we take the example of a right to work for an individual whose leave has expired, we've got different wings of the Home Office giving completely different information, which leaves all visa applicants, employers totally in the dark. We've got a newly created coronavirus immigration team providing responses to permissions to remain in the UK beyond the expiration of visa leave, because individuals can't travel home, confirming that those individuals have a continuation of their previous conditions of leave, in writing as confirmation, but then that's not backed up by the employer checking service, who confirm that those same conditions apply when it comes to the right to work. And certainly that means there's no statutory excuse for employers who would want to rely on the necessary documentation, because again, the Home Office haven't advanced what right to work guidance they have states to allow for different permissions that they should have been aware were coming, because they set up the coronavirus immigration team. Then with delays, and just to take Adrian's point a bit further, so for the NHS workers that have been included, i.e. doctors, nurses, a lot of the changes that were required came late. So I was getting questions from particularly doctors who wanted to work longer hours for the NHS, but the Home Office the Home Office didn't evolve their guidance to say that doctors could work beyond 20 hours a week in supplementary employment, didn't allow students to work longer hours than the previous restricted time frame. And it caused a lot of concern. We were getting questions from students, particularly, who wanted to help out. We had skilled professionals who were able to assist with the NHS lack of resourcing that couldn't do that, because they risked their, contravening previous requirements and obligations they had on restricted work. Very quickly, as I say, a lot of these are ongoing issues. We rarely have joined up thinking from the Home Office, and it's shown by things like the offer to NHS workers to not pay the NHS surcharge, for example. That's something that shouldn't really be paid by anyone who is also paying paying national insurance when they come to the UK to work. So there's a double standard that I think this pandemic highlights, and that I think we should use it as an opportunity to reverse before, certainly later in this year, the planned increase in the NHS surcharge.
Forgot to unmute myself. Now unmuted. Thank you very much, Ahmed. We're going to move on to Yawar. Just to remind everyone, if you want to ask a question or make a contribution, then if you get your hand up quickly, you'll be one of the first. So if you can let me know if you do. But we have two more speakers, and can we move on to you now, Yawar Abbas, please?
I thought I'll expand further on what Adrian and Ahmed said, and I think I'll slightly try to focus on, employment-based migration as well, because that's another particular area which is really affected. As Ahmed mentioned, that the COVID helpline and the UKVI proper, they don't seem to be speaking to each other. It's a case of left hand not knowing what the right hand is doing. We were told that there is advice with the Home Secretary regarding lots of issues, but it has been a couple of weeks now and nothing has been done on that. An example is that, just to give some context to listeners, that when individuals come to the UK, initially they're issued with 30-day visas, and then they have to collect their biometric permits from within the UK. Now, those 30-day visas are expiring or have expired, and initially we were told that actually they would be automatically extended, but now we are being told that no, they will need to actually apply for new 30-day replacement visas. But then the advice is with the Home Secretary to change that, but nothing is happening. So just to give some context, these applications, for example, for a family of 5 can cost around £20,000 in Home Office fee. So to ask these people to actually pay additional thousands of pounds for replacement visas is just, is atrocious. So I think we should be raising that and pushing back on that they need to have automatic extension. Further, as Ahmed mentioned about right to work checks, and again, from experience, the employers checking service from where employers can get information whether the person has the correct permission to work, they are not being really helpful. An example recently has been that sponsored workers can change employers before their new visa has been approved, but when you check that with the employers checking service, they do not have this information. So practically speaking, employers are finding it really hard to actually employ people who are changing sponsors before their application has been approved. And I had a call with the Home Office on this aspect about some changes to right to work guidance, but they said that, oh yeah, it'll be fine, we'll be flexible. But when I pushed on the fact that actually will we have something in writing, they said that not yet, and it's not urgent. So in practical terms, these are really serious issues. I thought I'll touch on the fact that actually, this whole thing, the pandemic has taught us that basically these key workers, as Adrian mentioned, cleaners, porters, other staff, they're the backbone of NHS, and they're essential workers. But under the new immigration system, which the government wants to bring in from next year, they will be classed as lower skilled workers. So I think we really need to push back on this and think about the fact that actually they are not lower skilled, but essentially they are essential workers. I'm hoping that what this pandemic teaches us is that the language which the government uses around migrants will be softened, and the rhetoric around migration, etc., will not be brought back in a year or two when people forget about this. So I think there needs to be a recognition of what the migrant community has contributed to this country and continue to do so over time.
Thank you. I certainly think that this pandemic has really shown us who the essential workers are. And I think that's coming through loud and clear. I now have the opportunity to introduce Holly Lynch MP, who's been the MP for Halifax since 2015 and is now 2 weeks into her job as the Shadow Immigration Minister. Holly.
Yeah, thank you very much, Catherine. There's certainly not much going on. It really has been a baptism of fire coming into this role, but thank you for inviting me to take part in this panel and webinar this evening. So yeah, MP for Halifax. I represent quite a diverse community here in West Yorkshire. I'm also on the Home Affairs Select Committee, and we were very grateful to have Adrian's insight, giving evidence to that Select Committee, again looking into the whole raft of issues that are affecting migrants and migrant communities there yesterday. So having been asked to be the Shadow Immigration Minister, in representing a diverse community, you would just expect that we are dealing with unprecedented requests for support, advice from constituents on a whole raft of issues in the Parliamentary Office, and really significant numbers of those are in relation to immigration. As other panel members have already said, I think what this has also done, the coronavirus, is just shone a spotlight on these are not new problems, but problems affecting migrant communities and migrants that have just been absolutely exacerbated by the coronavirus pandemic. In addition to that, I'm also working on Labour's response to the immigration bill, which is absolutely imminent. And I also thought in my opening introduction, I would just give your members a sense of where we are with the immigration bill. So Really, it is a necessary piece of legislation that will just bring about an end to free movement as the government progresses with leaving the European Union. It is really quite narrow in scope, but it is the second time we've seen this piece of legislation. It fell because it didn't complete its committee stage prior to the snap general election at the end of the last Parliament. It was due to be back in the House of Commons chamber for its second reading yesterday. That hasn't happened, and really it's just for practical reasons. Because it would be a contentious piece of legislation, I think it's fair to say, we would expect divisions on that. Whilst this hybrid parliament has come into effect, allowing people to partake in holding government to account and scrutiny and some types of debate and exchanges in the chamber, the technology isn't there yet to facilitate safe divisions and safe votes. And we would certainly be looking to hold a vote on this piece of legislation. So it has been delayed for now. I expect that it will not be delayed for any more than perhaps 2 or 3 weeks, whilst the technology is just introduced that would allow us to do that. As you would expect, I'm certainly using that time to try and work with organisations, charities, experts like yourselves, to work on a raft of amendments to try and shape that and push and pull it into something that is much more workable for all those that we know need it to be. On those whole other raft of issues that are affecting migrants, everything from immigration, detention, visas, no recourse to public funds, we are also trying to find the right ways to make very public calls on government to do the right thing and change course in a number of areas. This week, I very publicly called on government to end no recourse to public funds. I do just think that it's something that for a very long time has been incredibly difficult in terms of supporting some of those people who just need that bit of extra help in our communities. As a constituency MP, you see that time and time again, but particularly in the midst of the coronavirus pandemic, it is forcing people into almost impossible situations where they're having to determine whether they go to work and perhaps not adhere to public health advice, or stay at home without pay, without support, and face destitution. That is an impossible situation for people. We've particularly highlighted concerns where, because we are seeing an increase in domestic violence, if somebody as a migrant feared that they could not access support in those situations because they had no recourse to public funds, that would be absolutely unacceptable. So we've called on government to think again on that really difficult policy. We are, of course, as well using the opportunity that the immigration bill is imminent to see what more substantial amendments we might want to table to that, to force rethinks that would help alleviate some of the pressures because of the coronavirus, as well as just some of those ongoing issues that we know are uncomfortable and we're not happy with. We are working up the detail of that, and we'll be looking to hopefully work with some of your members on helping us shape that so it's as good as it can be. It does come with the caveat that the Government Minister for Immigration has already been very, very explicitly clear with me that they are not minded to adopt any amendments that we might propose. There are always other tactics that you can perhaps use and work cross-party, but we're just very mindful that this government has got a majority of 80, but it's not that we will not use every opportunity and platform that this bill presents to talk up our concerns about some of the detail of it and propose alternative improvements. I thought I would just touch on the EU settlement scheme. That is a community who are working in a very time-limited window to apply for their settled status. And the deadline for that is June of next year. We don't know how long lockdown will go on for. We do know that helplines have closed. We do know that some of that face-to-face support for people who perhaps in more vulnerable groups who need some face-to-face support in applying for settled status, that has stopped. And so we will be looking to push government to consider everything that we need to, including extensions to that deadline, to make sure that people have been able to undertake that process over the course of the next few months. And as Yawar's already perhaps mentioned, I think it's just worth finishing on, for me, the coronavirus has actually opened up a really big space that we haven't seen for a while for us to have a more constructive conversation about immigration. I think people are genuinely humbled and grateful for the contribution that migrants at this time are making, particularly in healthcare, but also in social care, and considerations for things like food security. People are anxious about things that they've not had to worry about for a long time, and are looking to the people who are undertaking those roles and that work, and are just very grateful. And I think that's a genuine sense of being humble and grateful. So it has just created that space, and I think it's useful for us that we've got to make the most of it, and long may that continue.
Thank you very much. I think we've got Adrian Williamson QC wishing to ask a question. Adrian, are you there? I can't hear him. So I'm going to, oh, there you are.
Sorry, I seem to clack it. Yeah, the question I wanted to ask the practitioners is what are the challenges of actually seeking to deal with urgent immigration cases at the moment? Because obviously the courts are on furlough to a considerable extent, and clearly there are going to be a lot of immigration issues which have been touched on in the longer term. But I'm just wondering what the short-term challenges are, and to what extent those are being able to be surmounted.
Adrian, can we start with you?
Yeah, sure. There are, I mean, the courts are furloughed to some extent. There are practice directions for both the immigration chambers of the first tier tribunal and the upper tribunal to allow for urgent work to continue remotely and for documents to be filed at specific email addresses for urgent work. And there's a parallel procedure for immigration judicial review, as you'll be aware, is distributed between the High Court for certain matters and mostly goes to the upper tribunal's immigration chamber. But the administrative court also has a procedure for urgent applications in relation to matters which bear on detention. So there are procedures to operate things remotely. How effective they are is another question. Bail hearings are being, immigration bail hearings, that is, are being given a priority in terms of remote hearings. And the courts are, immigration tribunals have turned all immigration appeals into case management hearings, which are to be conducted by telephone. And there's a pilot practice direction from the senior president of tribunals for how those are to be disposed of. The key issue for us in terms of the right to a fair hearing is that there's a presumption in cases that they may be disposed, appeals, statutory appeals, so not judicial reviews, may be determined without a hearing. And then there's a special procedural amendment rule to both chambers, both the first tier tribunal and the upper tribunal, to allow appeals to be determined without a hearing. And so the key issue is that really necessary? Because hearing not just oral evidence, but oral submissions, often you're rolling a ball uphill in the immigration setting because the law is set by one of the parties, the Home Office. And the question is, should there be something like that at all? And if there is, what sort of criteria should there be in order to have a hearing, which seems like an extraordinary thing to have to say, but in what circumstances should we have should we have to ask for a hearing in this situation, albeit a remote one?
Ahmed, is there anything you'd like to add to that?
So away from the courts and litigation of it all, there are issues, just practically speaking, for applicants of all types. So the availability of arranging very prescriptive documentation for submissions, whilst is not absolutely vital because it's not possible to finalise submissions and through biometric enrolment, and whilst it doesn't impact the legal filing of an application online, for some applications it makes it impossible to get the documentation needed for the filing to meet the requirements of the application. For example, for indefinite leave to remain, if you haven't arranged a Life in the UK test, you now can't attend a test centre to arrange that that test certificate or the reference number now. And so, you know, you'd submit the application before a visa expires, for example, to have it an in-time application. But technically speaking, you're not meeting the requirements of that further leave, that indefinite leave to remain. So there are issues like that are arising, which I'm guessing practitioners will work around, but which do leave applicants in, particularly those with limited leave to remain expiring in this period, in precarious positions.
Thank you. Yawar, is there anything you'd like to add?
Yeah, just expanding on what Adrian and Ahmad said, that I think it's worth bearing in mind that the entire immigration process is you know, it's very prescribed, and it's a massive tick box exercise at the Home Office. The fact is that actually, if some applicants are unable to, you know, obtain these essential documents such as Life in the UK test or English language test, etc., their applications can't proceed further. So what that then also means is that actually, I'm actually dealing with a case right now where the individual has been here with his family in the UK for over 5 years. They qualify for indefinite leave to remain, but because they can't obtain some essential documents, and his job is actually at the risk of being, you know, furloughed or even being made redundant, he might end up in a position that actually he can't apply for ILR. So I think there needs to be a bit of a culture change at the Home Office as well in terms of being more flexible, because for quite some time there has been that mindset that, you know, it's a tick box exercise. If you have this, that's fine. If you don't have this, then it's very hard for them to exercise discretion. So yeah, I think that's what needs to be done there.
Thank you. I mean, that was aimed at practitioners, but Holly, are you hearing similar stories? I think we just need to unmute.
Thank you, forgive me. Yeah, and that's from both a perspective of being a constituency MP, but then also the evidence that we're hearing to the Home Affairs Select Committee and in this more national role as well, absolutely. The government are, you know, sort of saying they're going to be flexible on some of this, and we heard evidence previously in the committee from representatives of Border Force who were keen to stress that they were taking common sense approaches, that there was going to be a relaxation. We are seeing policy statements from government, but I think the legacy of the hostile environment means that without really clear legal frameworks underpinning legislation that address some of these issues, there is still an awful lot of anxiety and uncertainty on the part of people whose visas might be expiring or encountering problems. So yeah, absolutely, and it's something that we'll be pushing for more clarity and legal framework to make those, you know, to deliver those changes that we need to see for people.
Thank you. Our next question is from Shahid Nadeem. Shahid.
Hi, I would like to ask a question about if somebody here on a visitor visa, they were intention was to go back, but they couldn't go. And right now they are facing some financial difficulty. Is it possible for them to do any kind of the job? And secondly, for those people who came here on EA family permit in January or February, they want to renew it. Is the Home Office booking some appointment for them? And one suggestion is this, as one of the panelists was talking about, that if somebody is meeting some certain criteria, especially the financial criteria at the time of their application, but they could not make that application due to this pandemic, is it possible for Holly to give suggestions on this incoming immigration bill? The people who are fulfilling the requirement on the date of their application, they should be considered valid even if they lost their job or something like this.
Thank you. So 3 questions in one. Can we start with Yawar, please?
Yeah, I mean, with visitors, especially basically what you mentioned, that they can't go back and can they work? The fact of the matter is that visitors are not allowed to work. And there has been no change in that. But I think, yeah, that is something which basically, you know, in a practical way, which can be raised with the Home Office. Is essentially we're seeing that, you know, Tesco, Amazon, etc. There are lots of vacancies. So there are businesses here in the UK which need workers. So maybe that is something which can be considered, and they can be they can work. Yeah, that's what I would say.
Thank you. Ahmad.
Sorry. So the visitor visas, yeah, as Yawar says, no right to work. So so I think that's deals with that. With the appointments for EU applications, I think I don't know if you're getting at this specifically, but certainly for individuals who have arrived on family permits who then want to extend their stay, all appointment centre appointments are discontinued, so all applications have stalled from that perspective. For family permit holders who are looking to switch into the EU settlement scheme rules, there are certainly challenges for non-EEA nationals who are applying as partners of EEA nationals in finalising their identity verification, because they're not able to attend a verification confirmation appointment at a local council centre. So I certainly have a few family permit holders who are waiting now for the availability of those councils to reopen those appointments to be able to complete the first stage of the settlement scheme. Further reason why we need that extension, if we can get it, to the timeframe within which those applications can be submitted and finalised. And people are, I think, understandably not happy about sending their passport into the Home Office at this time. So that is the only option, is to wait for those council appointments, or then to send your passport into a Home Office department in the middle of a pandemic, which is not something I imagine people are comfortable with. I hope that answers the question. I don't think I took a good enough note to be confident, though. Maybe Adrian's got something further to add.
Well, let's go to him, Adrian.
Hi. Yeah, if I could pick up on the question of the minimum income, and I think it was a family reunion question, which we haven't touched on. And there's obviously an 18,600 income threshold for family reunion, and of course for income levels for the person who's sponsoring the person to come to the UK as a spouse or a civil partner and the like. This is a really good moment for us to campaign on this issue that there shouldn't be a minimum income threshold, because at the moment people on medium to low income jobs are having precarious circumstances forced upon them because of either they're put on furlough or they lose their work. And so when you can see that people who are settled, who are sponsoring family members to come to the UK, will have trouble meeting that threshold. But the threshold has always been controversial, and it's always been something that Labour has campaigned on, that we shouldn't have minimum income thresholds. The old test was your income had to be adequate, and your accommodation had to be adequate, and you looked at the practical circumstances of that. But even going back beyond that, there used to be no income threshold of any description, whether it was a bright line figure or an adequacy test. And so we can see now in the lives of people who are necessary to the economy, whether they're working in the and society, whether they're working in the NHS or whether they're just working more broadly in society, doing jobs which are not the sorts of jobs which are prioritised under the work permit Tier 2 scheme, that putting family reunion visas, making them subject to this threshold, it's a class issue basically about family reunion for people in different situations. And it's something that the crisis shows that more people are unable to meet it. And it gives us a lever and potentially a campaigning tool to get rid of it on a broader basis across the medium term.
Thank you. Holly, would you like to comment before we go on to our next question?
Yeah, certainly. And I think I understood the element of the question that was more directed at me. I suspect we're going to have very limited opportunities to actually amend the bill. But that's not to say, as I've already said, we won't have a really good go at pointing out where we think there are injustices in it. We are really concerned that there will be people through no fault of their own, particularly on the family visas, who will potentially fall below what are the annual salary requirements because they've potentially been furloughed or lost their jobs and are just in a real work-related vulnerabilities that have a direct impact on their visa because of the coronavirus. We are very, very aware of that, and we'll be looking again to work with people like yourselves, experts, to make sure that we can try and shape this bill so that we are overcoming some of those problems. Whether we can just make the case to government and get them to reflect on it themselves is definitely an option that's still available to us. Whether we can actually amend the bill, as I say, we'll do everything we can on that. We very much understand that that is a problem. We're not happy about that at all, and so we'll be doing what we can.
Thank you. Before we hear from Deba, we just had a couple of contributions on in writing. Charles Bishop has said it's worth noting that the government can extend the deadline to the settlement scheme without having to extend the transition period. The former is much less politically toxic to the current government than the latter, and has later also said that she'd like to, that it's a good moment to campaign on the prohibitively expensive application fees, and in particular the proposed increase to the immigration health surcharge in October, which has already been mentioned. But I think we're just going to be hearing from Deepa rather than seeing her. Deepa?
Hey, yes. Okay, so my question, I just want to pick up on what Holly said about the no recourse to public funds policy, and just how pernicious and far-reaching it is, because in my local area, I'm hearing reports of free school meals being denied to people. You mentioned domestic violence. Women are being refused healthcare because of this. I know employers are wondering whether they can furlough certain employees because it might be deemed as public funds. And so just on this, and another thing to mention as well is that in the domestic abuse bill, which is currently going through the House now, migrants aren't covered as well. So I guess what the point you make is it's going to be impossible to make amendments to any of these bills. I know that recently there was a Court of Appeal judgment where the government's right to rent scheme was where the landlords have to carry out immigration checks, from what I understand, was ruled to be racial discrimination. And it just seems with these government policies, it's becoming increasingly necessary to have to go through to the courts to try and overturn them. And I'm just wondering what the panel thinks we can do in terms of possibly pursuing that kind of course of action.
Thank you. And Deepa, can I just, before, I think we may have lost you already, I was just going to note that your own professional background means that you do have particular insights into the impact on domestic violence. I didn't know whether you wanted to just mention what your work is and why you've got direct experience in relation to that.
Yeah, well, the organisation I work for, Rights of Women, we give free legal advice to women. We give it in immigration, family law, employment law. I don't practice immigration law myself. Oh, sorry, that's my phone. I don't practice immigration law myself, but we're a violence against women charity, and I know that this is, just as Holly said, this is it's been a long-standing problem, which has near enough been ignored, and it is an opportunity for us to talk about these things. No.
Adrian, are you happy for me to start with you?
Yeah, sure. I mean, I think this question of no recourse to public funds is what it does is it also, if you have a no recourse to public funds restriction, it also can also block you from receiving things which are not considered to be public funds. And so for example, it's often the trigger for increases in permitted public funds as well. If you have access to one fund that may be restricted if you're a migrant, but another person who's a British citizen has it, that person can then go on to get an additional premium in another type of public fund because they have access to one sort of fund, and also to certain forms of support in the third sector, which may be triggered by, is this person on benefits? Do they have access to public funds of some description? So it doesn't just bear on the benefit itself. It's a trigger, often having access to a certain fund, to other forms of support, not just from the state, but from the third sector. And so it's particularly pernicious in the context of survivors of domestic violence, and in the context of migrants who are shut out from what you might call the broad social safety net. There is scope in the bill potentially to look at some of these things, but I think one of the things I would say about the bill, which you have to be very careful about, is that in the bill there are things called Henry VIII powers, which we all know about, which obviously allow ministers by regulation to amend primary legislation. And the scope of the one that relates to immigration is so broad, it can amend something in connection with immigration, which includes access to benefits and services, according to the Home Office background paper on it. And so we can expect not just the continuation of no recourse to public funds unless we're successful in lifting it through a campaign to put pressure on the government, but also actually for EU citizens and their family members who currently have access to benefits and services, potentially for Henry VIII powers to be used to amend primary legislation to restrict their access to benefits and services after the end of the transition period. And we have to be aware of that it's in the background documents that the government have published already, that they will use that sort of power, and that would avoid the primary level of parliamentary scrutiny, of course, if they use the Henry VIII power to do it. So that's another very important issue, I think, on which we have to campaign and try and see what we can do. And so the scope, the reason it's a possible gain is not so much in the House of Commons potentially, but in the House of Lords, where the idea that the Henry VIII power is so broad that it can amend a non-immigration area when it's contained in an immigration bill might be a rule of law issue on which we can build a coalition of support.
Thank you very much. I'm going to come on to Holly, but before I do, I just wanted to read out a comment from Sonali Nayak, who said that horrifyingly, the Court of Appeal held that the race discrimination experienced by those who were seeking to rent was lawful and intended by Parliament. So I think that's just in relation to the Court of Appeal judgment that was mentioned by Deba. Holly.
Yeah, and I was just looking for an extract from a letter that I also read out in the Home Affairs Select Committee yesterday. So on the 26th of March, Luke Hall, Government Minister, wrote to all local authorities. And within that letter, it said he was asking them to utilise alternative powers and funding to assist those with no recourse to public funds who require shelter and other forms of support due to the COVID-19 pandemic. So you get a sense there that government understands that no recourse to public funds is a massive problem, a public health problem in the circumstances. It is calling on local authorities to assist people, but to utilise alternative powers and funding is so ambiguous and is passing the buck on to local authorities who at this moment in time have not got any spare cash at all, after years of austerity, to find the funding to do that themselves, to utilise alternative powers to almost circumvent the existing policies and legislation that are there to prevent local authorities to providing that support to people. So this just seemed to be absolutely crackers position for government to take. We agree, and I think they understand in principle what needs to happen, but for them to have articulated it in that way to local authorities, to me, is just not good enough. And so that was one of the reasons why we made that very public call for government to just be clear, express to local authorities where that money is going to come from, so that there are no barriers to providing that much needed support to those with no recourse to public funds.
Thank you. Ahmed, is there anything further you'd like to add on that?
Not really substantively. It's not my area to add to what Adrian and Holly have said, but other than to say that if this is a point that we are going to campaign on and push on, then I do think, as Charles has mentioned in the comments and as I mentioned in my talk, that we should be looking at folding in access to the NHS as an equivalent right for migrants as it is for people in the UK, not just reversing the amount of money that it costs. Initially 200 for most, then 400, now 624 expected pounds a year, expected later in the year. But acknowledging that people should have recourse to public funds wherever they're from, because you're a migrant, you shouldn't have to pay twice for the same NHS access. You're paying national insurance contributions. Why are you also paying an NHS surcharge? Then maybe there's an argument for dependents, and that's a separate point. But certainly for those that are working or in work, it seems ludicrous. So I think it's important that we use all of those threads in any such campaign, and working on, as Holly mentioned, I think the goodwill that we can sense towards the migrant community in the UK at the moment.
Thank you. Yawar, anything to add? Don't worry, we've got at least 3 more questions from people who haven't yet asked questions. So what I'm going to do is to take those 3, and apologies for people who haven't been able to ask their question. I think we're going to start with Omar.
Hi, hello. I guess so. I think I would be interested in your thoughts on how, you know, coronavirus has impacted the perception of immigrants. I mean, I think in the UK, there's been a greater recognition, you know, of their role in the NHS in particular. But then in the US, for example, Trump has just introduced a green card ban. So, you know, that you could see it also turning quite nasty potentially from some forces. So I was just wondering about your thoughts on that.
Okay, I've got one question that's written from Jack Hoban, and he says, are we going to be able to question the government on treatment of immigration detainees? Promises have been made as to the release of detainees, but challenges to detention continue to stack up in the High Court. It appears the Home Office currently has no working estimate on when removals of those detained will resume, yet is indefinitely detaining some people who are not classed as high-risk offenders. It's something that certainly Adrian briefly mentioned in his initial remarks. We're going to take another question from Shahid Nadeem, and then I will ask all of the panelists to answer those the three questions that we'll have. So Shahid.
Yeah, thank you very much. I would like to ask about government's policy for switching within the country for those applicants who cannot go back to the country and apply entry clearance, and they can apply from here. Is this only for the family application, or is it also for the point-based application? And secondly, if somebody is on a short-term visa, like a visit visa, can they also switch within the country? Because ultimately, visitor, they cannot apply tier 2 general visa or the family visa within the country. So can they switch within the country or not, according to the government's policy, which was announced last month, I think so.
Thank you. I think Shahid's managed to get 5 questions in his 2 shots. But can we start with Adrian, if that's all right with you?
Yes, yeah, no, of course. I mean, as far as the dealing with Omar's question first, as far as the view of migrants amongst the settled population, I mean, there are 2 things. I think we should distinguish between the broad sympathy which currently exists among the population and the media treatment of these issues. And what you tend to find is that the media, who are traditionally perhaps hostile to migrants, temporarily sometimes flip the other way. So we saw that briefly over Windrush, and then we see it particularly over the question of forced migration across the Mediterranean, when there were people drowning in the Mediterranean initially. There was a huge amount of sympathy in the media, and then it drained in the right-wing media particularly, which is most of the media, and then it drained away. But I think what needs to be done now is for the sympathy which exists more widely in the population to be turned into political pressure, sustained political pressure, because we've been at the high tide of the sympathy at the moment, and as the crisis abates, the risk is that people become a little bit complacent about the contribution which migrants make. On the detention question, I think that there's obviously action going on at the moment through the detention action judicial review proceedings in the High Court about the remaining people in immigration detention, and about the government's policy towards them, how many there are, the conditions that people are kept in detention and so forth, and the risks to them. It's absolutely right, if removals are not taking place within a reasonable period of time, those people are potentially unlawfully detained and should be released. They should also be provided in any event with secure and safe, in health terms, accommodation as well. So there are connected questions there about the use of accommodation to accommodate people who are detained. On the question of in-country switching, which is a technical question about how you make applications, there are 2 things going on. People whose leave was due to expire by the end of May can apply for short-term extensions using an online form. But my understanding is that the Home Office are accepting in-country applications, although whether they grant them or not is a different matter, from people who are unable to travel. But if you're here with leave to remain, and you have the possibility of an extension because you're on that sort of route, then you'll be able to make an in-country application.
Thank you. Yawar, can I come to you? Because I'm conscious of time, any concluding comments that you would like to to make, please do.
Basically, I would just say that I agree with Adrian that I think what needs to be done is there needs to be sustained political campaign and pressure on the government to make sure that this positive, view of migration, etc., is not overturned, and we don't have the media going back and going back to its rhetoric about migrants.
Thank you, Ahmed.
Just completely echo what Yawar just said, and to refer back to what he said in his opening 5 minutes. Yes, sustaining pressure, but this is a really good opportunity in very particular areas to shape how the future immigration system works and the kind of social contract the country has with its migrant population, because we've got an immigration bill and because there's a new system that's being proposed that quite substantially changes a big section of the immigration rules, supposedly over the course of this coming year. And I'm thinking particularly, as Yawar mentioned, the occupation codes of a reshaped look at who key workers are, so that we can offer as a country the kind of positions for a wider set of occupation types for people the country really needs, and that we know now the country really needs, and the opportunity will be there with the opening up to sort of a wider skill set under the new proposed new system.
Thank you. I'm going to move on to Holly, but I just wanted to read a contribution from Sonali Naik again, who notes that the Home Office is required to respond by the end of today to detention action as to the fate of detainees. And I am conscious, Adrian, that I hadn't given you an opportunity for a final comment, so I will come to you after I go to Holly. Holly.
Thanks, and I think I was going to focus my comments on detention immigration, because I know that was a question that was specifically directed at me. We're very aware that there are problems in this area. In the last immigration bill, the then Home Secretary Sajid Javid, I can see in his second reading contribution, went to great lengths to try and stress that immigration detention was not within the scope of the bill. The clerks did allow amendments on detention, because I think they were well within their rights to do that. So it does open up the opportunities for us to revisit some of that with this piece of legislation. In the here and now, we are trying to put pressure on government, and actually in the conversation that I had with the Immigration Minister this week, he tried to give me assurances that they were looking to provide community options, alternatives to those in immigration detention now. Bella Sankey, the director of Detention Action, gave evidence yesterday as well, and I spoke to her further this morning. I think I'm just very mindful that for us, who are contributing to that push to make sure that people who absolutely don't need to be in immigration detention are moved out into the community, what we are hearing actually though is some of those support services that we would want them to have, and proper accommodation where they can self-isolate, and then other wraparound care, that is lacking in communities as well. So I think that's just something for us as sort of a labour movement to be very mindful of. We want them out of detention centres, but actually we need to know that that care is there in the community as well. We will be looking to probe further in the bill, I guess on two main areas. And this happened with the last time it had an airing in Parliament. We've got concerns around a lack of independence and scrutiny on decision making to detain somebody, but we also really want to, working with Detention Action, look at that 28-day limit to make sure that people are just not spending months and months in detention. There was a cross-party coalition of support for amendments to that effect previously, in the hope that when the majorities were much tighter, we could have forced government into some changes on that. Tactically, we will have to approach that in a different way this time, but just to give you a sense of that's where we are in sort of the here and now in managing the pressures with the coronavirus, but then look into the bill as well.
Thank you very much, Holly. Adrian.
Well, very briefly, just concluding remarks. The Home Office white paper on the future immigration system after the end of the Brexit transition period was published before the coronavirus crisis emerged. So there is scope to build on what's happened in terms of raising awareness, in terms of medium and low paid jobs now, and to say, look, this actually needs a revision because you did this before we had this particular crisis. It now no longer is fit for purpose. There's a legitimate lever there that we could broaden out the campaigning issue from and say, well, look, we need to relook at what the country's needs are as a light of our experience over the last 6 to 8 months by the time we come down to the end of 2020. And so just really to reiterate what Ahmad and Yawar said, and to say that that sort of scoping study about what the needs are, effectively the old research is redundant, and we need to look at this afresh, and we've got a good opportunity to do so.
Thank you very much. I want to thank all of our speakers this evening. It's been fantastic to have the opportunity to hear from Lynch MP, from Ahmad Namazie, from Yawar Abbas, and from Adrian Berry, who have been fantastic. And thank you very much for other members who were able to make contributions and ask questions. Next week, we have our webinar is on COVID-19 and civil liberties. We have Ellie Reeves, the Shadow Solicitor General. We have Adam Wagner. We have Shona Jolly QC and Lord Willie Back, the Police and Crime Commissioner for Leicestershire. So again, I think a good panel and a very interesting issue for us to be discussing. But thank you very much for joining our webinar.